Hi, everybody. I'm Gwendolyn Sterk of Sterk Family Law, and I have the honor and privilege to have Alex with, who's an attorney that practices in the area of employment law. Welcome, Alex.
Hi, Gwen. Thanks very much for having me.
Well, thanks for being here. Can you tell us a little bit about the area of law that you practice in?
Yes, I am a plaintiff side employment lawyer. I help employees who have been treated unfairly and unlawfully in the workplace. And that encapsulates all types of claims, discrimination type claims, retaliation claims, sexual harassment claims, wage theft claims, any issues that come up in the workplace that might have a legal angle to it. I assist clients with those issues.
And what would be the general process for harassment or discrimination claims? So somebody picks up the phone, they call you, tell you something's happening at work. What really is the process? So we're all educated in that.
Well, my process is to hear their story. I think that's crucial, especially in employment law, because every employer relationship is different. There are all kinds of different wrinkles to those relationships. So my process is to hear their story. And sometimes that takes several phone calls or several meetings to do that. If the client wishes to proceed with legal action, usually the first step is to go to the federal or state agency. That's on the federal side, that's the EEOC. And on the state side, that's the Department of Human Rights. They both do the same job, but one is under federal jurisdiction, one is under state jurisdiction. That is a necessary step if a client wanted to file a lawsuit, because under the law, they call it exhausting your administrative remedies, which is basically say you have to clear this step before you could file a lawsuit. So that's the first step. The agencies then investigate. Sometimes they'll take up the case and intervene on their own. Otherwise, they'll say, you know what, there's not enough here, which is, I can say anecdotally, that happens most of the time. And then at which point the employee has 90 days to file a lawsuit after they're given notice that the agency doesn't want to pursue their case. And then the lawsuit begins.
So let's say that I call you and you listen to my story and you think I might have a valid claim to be heard and to make. Is this something I have to pay you to do hourly? How does it work? Do you have to have a retainer? Can you explain that to our audience?
Sure. So my structure is, well, first let me say that my entire practice and business model is based on people who have just been put out of their livelihood. So adapting to that to that reality, I do a hybrid, which is an upfront deposit, which is enough to get me started, to learn the case, to research the law, to draft settlement negotiation documents. But I think that deposit also has another plays another important role, in that the client is invested in their case, because many times, this is a painful and traumatic experience that people have gone through in their life. And although clients may be angry, upset, wanting justice soon after it happened, Gwen, and I know that the litigation process is a long one and it's a painful one, and it requires a lot of patience. And many times people say, you know what, I've had enough. I want to put this behind me, and that's fine. But as someone who takes on these cases, I need to know that the person who I'm helping is totally bought in and invested and has skin in the game. And, even a small deposit, ensures that I have that commitment.
I understand that. I guess the follow-up question is, in these types of cases, I think sometimes there's an unrealistic expectation of the amount of damages that you can be awarded. So let's say that you're representing a plaintiff, somebody who's initiating a lawsuit in a retaliation or employment case. Is there going to be a huge financial payout here?
It's hard to say without knowing more about the case, but generally, no. Generally, damages are limited to, a few categories, and I'll walk through the general of it. So first is the back pay. So back pay is, it's the conceptually, I explain it. It's the money, it's the wages you would have earned if you weren't fired for an unlawful reason. Okay. And then there's front pay, which is similar, but it's that same formula, but it looks forward in time until the employee can find other suitable employment. There are also damages that you can recover for lost promotions, things like that, if those promotions were lost as a result of the discrimination or retaliation. There is also, mental anguish and emotional damages.
Sure.
Now, that is, those are termed non-economic damages because you really can't put a price on that, but you do have to prove it. And that's the one thing that I think a lot of people get caught up in. Generally, there are two ways to prove it. One is actually showing medical records showing that, as a result of this, adverse work action, you came down with, you suffered anxiety, depression, and things like that. You started to see a psychiatrist or a therapist. Generally, that's easier to prove because you have a third party physician or medical professional who can testify on your behalf that you suffered these damages. The reality is that many people don't avail themselves of those services either because they don't want to or they can't afford it. Because again, many people who have just been fired are living, they're not even living paycheck to paycheck.
Right.
For people in those cases, I like to tell clients to keep I've come up with a term for it. It's called a feelings log. And I call it that because I haven't come up with a better word for it. But, it's important to write down, to keep a record of how you've been feeling, especially if you're seeking these kinds of emotional damages. And write down how, if you're depressed, if you're anxious, what impact that those mental and emotional feelings have had on your life. Now, I want to say that when this isn't a diary, this is used for litigation. It would, if one were to create a feelings log, it would be produced to the other side. So keep that in mind.
Sure.
But this is what, this is your record of your feelings and how your emotional distress has impacted your life. And I think that's especially true given the amount of time it takes to get to trial. I mean, we're talking 1 and 2 now during the pandemic. It's a really long time to get to trial.
Absolutely.
So it's so important to have that reminder of how you felt in that moment.
How many cases do you think go to trial as compared to settle out if you make it through and you get a denial letter through either the EEOC or the Illinois Human Rights Commission?
You know what? I don't have the statistics. I can tell you anecdotally, I'd say half of my cases settled before any lawsuits filed.
Okay.
And then of the half that go to where a complaint is filed in a court, I'd say half of those settled before trial or before any major litigation motions or anything like that happens. So it happens during the litigation process, and then
Sure.
some go on to trial.
And, people have been wronged. I mean, there are situations where there is discrimination, there is something that occurs at the workplace that's inappropriate, and these claims are important, need to be pursued.
Yeah.
So the first action is if you're wronged. Let's say that somebody comes to you and something's occurred at the place of employment and they say, I'm going to terminate you, but I'll give you this severance package. And if you will sign a release of claims, then we'll settle with you and we'll give you the next 52 weeks of pay. Should people sign that, or should they consult with you first?
They should always consult with an attorney, whether it's with me or with a professional, because it might appear that the employer is giving you a gift, but they're asking for something very valuable to them in return, and that is, like you said, waiving all potential claims that you may have against them, and that even though they may say, in your example, give you a year's worth of salary, they may be getting off cheap for what they may have put the employee through. So absolutely, I think it's absolutely worth it. I'd say in all circumstances, when people are signing a separation or severance agreement, it's important to speak with someone who is an expert in the field, who can advise the person about what they're signing and why it's
What that
important.
means, right? What
Exactly.
it means and what the impact's going to be.
Yeah, and especially in a case, even if one is inclined to sign it and they don't really have the appetite to sue or anything like that, it's having an attorney like myself or someone else who does what I do, having an attorney look it over and explain, the import of it is a small price to pay to know that you've done your due diligence.
Right. And I think that's true whether or not you have a potential claim for discrimination, whether it be age, sexual harassment, whatever, or if it's just in this mass exodus where they say they're going to eliminate 50 jobs. I think
Right.
the same thing is true, that they need to consult with an employment lawyer, and you'd be able to provide this service, correct?
Absolutely, yes, I've done that and I continue to do that.
Yeah. And I think that's really important. Now,
Yeah, and I'm sorry to cut you off, but yeah, it's so important, and I can't emphasize enough. And the price it pays is pretty modest for someone like me to review a contract like that, compared to what you may be giving up. It's a
correct.
modest price to pay to know that you know exactly what you're signing.
Sure, and you might be able to negotiate something with regard to the company as well if you think that it's unfair or, there's really a claim here. So,
Absolutely, and that's something that many employees are just loath to do,
right,
because the power dynamic is an uneven one, and many employees just won't approach their employers for anything. It's just not something that most people are comfortable with. Um, that's not that's something I'm very comfortable with.
sure.
I mean, that's my entire business. It's my entire practice. So yeah, it's very important and it's valuable to have someone who can advocate for you and do the things that maybe you're not comfortable doing.
Sure. And you can imagine as a family law practitioner, we see a lot of these cases coming in because it affects your family dynamic. It puts a lot of stress on you when you have an employment situation. So we'll hear about these situations in the middle of a divorce process or just when they're getting initiated. And I want to say, just spend a little money, get a little advice to make sure that you're not giving up something that is left on the table there or giving up rights that you may have that you should be pursuing.
Yep, absolutely. And Gwen, maybe you've seen this too, but I've noticed that when I speak with clients and they've retained me and I start actually doing the work, their anxiety starts to go down because they now have a teammate, someone who actually knows what they're doing and is
Right.
familiar with the process, and is working on their behalf. And that just I found that that's a huge load off of my client's shoulders, knowing that they're just not going through this alone and that they have someone on their side who is an expert.
Right. And who can advocate for them, speak for them, and almost stand in front of them and say, no, you're not going to do that. Yes, there are things that litigants need to do themselves. They need to tell their own story. They need to testify. But I think that, the attorney as the role of advocate is really critical there. Tell me about the pandemic and what effect that has had over this area of employment law on the plaintiff side.
Well, there's been some federal legislation, as I'm sure CARES Act, and that is there are some additional protections for employees for taking leave related to COVID. Unemployment benefits have been extended, so there are some protections as a result of federal legislation. As far as on the ground, people have been let go because of COVID. There are a lot of people let go. I found that people have been let go under the auspices of a COVID layoff. But many of these people think, and for some of them, I tend to agree with them, that many of the layoffs are a pretext to letting people go for another purpose. Now, that purpose may be unlawful. It may be discrimination or retaliation, or it may be perfectly lawful. I like to tell my clients there are millions of ways that an employer can be unfair, but still lawful.
That's correct. It's hard to follow, but it's true, right?
Yeah, most people are at will employees, so we serve at our employer's pleasure. Now, but sometimes people are let go, and there are enough circumstances and facts that support client suspicions that they are let go, not because of a COVID, not because business has been going down, but because employers are using it as an excuse to let people go. And again, my experience is anecdotal, but I've seen that. And I imagine that we'll continue to see that as the pandemic goes on.
Sure. And, in totality, what do you think really are the protections of employees? I mean, we talk about that at-will employment, and most people are at-will employees, right? And so they serve at the pleasure, so to speak. And we don't like those old words, but that really is the case of their employer. But what protections really does the employee have, to sum this up?
There are many, but in general terms, employees have the right to be free from discrimination, where the basis of the discrimination is based on certain identifiable categories, such as race, ethnicity, citizenship, gender, whether they're pregnant, whether they're straight or gay, things like that. I mean, those are big no-nos. Those are things that employers should not do. Employers may not retaliate against their employees for seeking to avail themselves of the legal process as a result of discrimination. So, for example, if someone were subject to discrimination and filed an EEOC complaint, it's unlawful for the employer to fire that employee because of that.
Right.
Now, Illinois has some additional safeguards, like it's unlawful to discriminate against employees based on whether they've been arrested in the past. So that's a really nice protection to have. Aside from that, people are entitled to medical leave. People are entitled to a reasonable accommodation for a disability, so long as they're still able to perform their job. Employees really do. I mean, the legislation that protects employees could be better. It could always be better. But the law does protect employees. But what I found is that many times people are just not aware of the protections, or they're unaware of how far those protections go. And in those cases, it's really helpful to speak with someone who's familiar with the law and can advise them.
So if somebody wanted to get a hold of you and they wanted to talk to you and say, hey, Alex, this is my situation. Do I or do I not have a claim, or should I sign the severance agreement? How would they go about getting in contact with you?
They could give me a call on my cell phone. It goes right to my cell. So if I'm in the middle of dinner, I'll probably just ask to call you back. But my number is 708-228-6284. And you can also reach me by email. I'm on email all the time. And I'll spell it. It's my name, but my name is really long. So Alex Stamatoglou, AlexStamatoglou @gmail.com. And I'm pretty responsive either way.
Sure. It's such a great opportunity because people don't even know where to start. I think that that's the process. They feel paralyzed. They just lost their job. They know, or something happened at work. They know that something's wrong with the story. They don't know where to turn. Consulting with you is really the first step. All you have to do is place that call, right?
Yeah, exactly. And I think it's really helpful just to speak with someone who is familiar with the law and will listen to your story and tell you what your story means from a legal perspective. I think that's so important. I think just that process alone can unburden a lot of people.
Absolutely. And you're objective. You're not tied to it. You don't have that emotional connection in the sense of being there at that employment place. So it really allows people to sort through it.
Right.
Well,
I mean, many of my calls result in me telling the person, saying, you know what, your situation, it sounds like it really stinks. But I don't know that there's anything that's there.
absolutely.
That's
And
part
that's
of it.
okay. That's just what people need to hear. That's what I call
Mhm.
facts of life. It's just that meeting to get that structure to understand what's going to happen.
Yeah,
But I appreciate
exactly.
your time today. I know so many people that can use this help, and we appreciate you and you taking the time to be able to share this information today. So thanks so much for being with us. We really do appreciate it.
My pleasure, Gwen. Thanks for having me. This was great. And I hope you're surviving the pandemic well, and brighter days are ahead.
That's true. And we'll talk again. All right. Thank you very much.
Bye-bye.